I was on the Bigger Pockets forum and I noticed an investor who made a post specifically confused, wanting to know what is the best state to set up an LLC in for rental real estate. Now, this post is actually really important because making the wrong move here could cost you not only thousands of dollars in maintenance and fees, but it can also cost you actual asset protection if you're sued by greedy lawyers. I'm Jeff Hampton, asset protection attorney, the best-selling author of The Investor's Blueprint, Asset Protection Made Simple, and the founder of STR Law Guys. In this video, we are breaking down exactly what you should do and setting the record straight once and for all. What is the best state for you to set up an LLC in for your rental properties so that you can rest easy at night knowing that your real estate is protected from greedy lawyers. Let's start by reading exactly what the post said. Greg said, I have a new business my family is creating for real estate investments. We are going to focus on small multifamily first and then get into large multifamily. Where is the best state to open an LLC for this purpose? The first purchases are likely going to be California, Montana, and Texas. Thanks. I want you to focus on the critical part of this post. They said they planned on purchasing in California, Montana, and Texas. Why does this matter? Because our first must-do step when setting up an LLC is number one, we should always set up an LLC in the state where the property is located. Why does this matter? Because there's a principle under asset protection known as home state rules control. In other words, if you are sued for a slip and fall or serious injury at your rental property, the law in the state where the property is located will control. That means if you set up a Texas or Wyoming LLC and then dump the title into that out-of-state LLC, you will not be able to use that out-of-state law to protect your rental real estate in California. Think about it for a second. If your California property is sued, you will be hauled in front of a California court, in front of a California judge, and California law will control. The court's not going to care if you set up a Wyoming LLC and transfer title directly into that Wyoming LLC. The court's not going to care if you did that at trial because Wyoming law does not control under that example. So if Greg plans to purchase a property in California, he should set up a California LLC for that property. If he plans to purchase a property in Montana, he should actually set up a Montana LLC for that property. Now, what about Texas? Yes, he should set up an LLC for his rental property in Texas. However, if he plans on purchasing multiple properties within Texas, he could actually make it easier on himself by setting up a series LLC to hold all of those properties. What is a series LLC? A series LLC is an LLC that allows you to place multiple properties within each cell of that LLC, which now makes it easier for maintenance and all your tax filings. However, it gives you total flexibility in the event one of those properties is sued, you're not held hostage during the lawsuit. Now, what exactly do I mean by this? Well, normally, if you just used a regular LLC and you stuff multiple properties within that LLC, if a greedy lawyer sues you, all of those properties within that LLC are now frozen. And if you lose the lawsuit, you could actually stand to lose all of the properties in the LLC. However, a series LLC allows you to place each property into what is known as a cell within the series, and now you'll have less tax returns, much easier, a single filing fee, much easier to maintain, while also being able to establish some separation between each property so that you don't lose all of your eggs in one basket. But wait, Greg wanted to set up these LLCs primarily for asset protection, right? Here's the problem. Not all states' LLC laws are created equal. Some states, like Texas, Wyoming, and Delaware, have great laws, but other states like California, New York, Florida, and Tennessee, their laws are downright terrible. Unfortunately, California is one of those terrible states for LLC protection, whereas Texas does provide you quite a bit more. Now, how do we know this? Well, generally speaking, you want to look at the law for each state that you're considering to purchase in, and you want to make sure they have three primary components for asset protection. Number one, you want their laws to provide privacy. You want to keep the prying eyes of greedy lawyers from being able to find out you're the member or the manager on an LLC, because if they find out, they will do what's called asset searches. And if you have other assets that the lawyer thinks they may be able to get access to, you become a bigger target. Number two is what is known as charging order protection. You want to make sure that you actually have this in place because this is one of the most important parts of asset protection. Normally speaking, if I were to sue a California or Florida LLC and you had rental property in it and you lost the lawsuit, I could get what's called a forced sale order to make you sell the property to pay me on the judgment. But if you have what's called charging order protection, now I can't make you sell. Even if I won the lawsuit, as long as you continue to pay your expenses and don't give yourself an owner's distribution, you can actually wait out the lawyer. By doing this, you create an enormous disincentive for the lawyer to want to sue you, and now they're 10 times more likely to want to go down and just get an insurance settlement from your insurance company. And finally, you would like to have what's called single member LLC protection. Why? Because if you're filing as a single member, you want to make sure that this isn't going to be treated as an alter ego by the courts and the judges in your state, because you're setting it up not only for tax efficiency, but also asset protection. Although Texas has some of these features, unfortunately, California has none. So how can Greg protect his rental properties in California if the law in California is terrible for asset protection? Let me introduce to you the holding company strategy. If Greg sets up a single member LLC in California, and then he does an actual title transfer and gets the actual property within the California LLC, he can now have that single member, instead of it being him, it can be a Wyoming or Delaware LLC. And now, even though California's law is terrible, he can now borrow Wyoming or Delaware's amazing asset protection laws for protecting a property in a state with weak laws. Well, wait a minute though. How exactly does this help Greg? Well, normally, if Greg only set up a California LLC, if I wanted to sue him, I'm going to go to the California Secretary of State and they are going to tell me that Greg is a member or a manager. And I am going to be able to do an asset search on him to find out what other assets he owns. But on top of that, I'll also know that if I can win this lawsuit, Greg has no charging order protection and I can force him to sell the property. But if he makes the Wyoming or Delaware LLC the single member of his California LLC, when I go to the California Secretary of State, there's only one member, and I got to go to Wyoming now because that's the member, the Wyoming LLC. When I get to Wyoming, I learn there's privacy laws, which means now I won't even know Greg is associated with this property at all. And then secondly, I'll also know that he has charging order protection, which means even me as the attorney, if I were to bring the lawsuit and win, which I have to pay for all the expenses out of my own pocket under a contingency fee, if I win that lawsuit, I can't make Greg sell. And if I can't make Greg sell, then how do I actually recover? I might actually win the lawsuit, but still lose because I might unable to collect on the back end, which now incentivizes me as the lawyer to go after an insurance settlement and not try to risk it all with a home run swing and striking out because there's charging order protection. Finally, Wyoming also provides single member LLC protection. So Greg doesn't have to worry about setting up a single member California LLC or even his Wyoming LLC in that regard because he has that protection under Wyoming law. This helps with paying less in tax filings. So what's the real solution here? You must always start with how strong the law is in the state where you are purchasing your properties. For example, if Greg had purchased all of these properties in Texas, he might not even need a holding company strategy here because Texas already has very strong asset protection laws. Now, if you're a real estate investor and you want to make sure you can protect your rental real estate from greedy lawyers in a lawsuit, check out the link down in the description below for a free strategy call. Or you're welcome to download our free ebook, The Ultimate Guide to Protecting Your Rental Real Estate. Finally, if you really want to go down the rabbit hole and learn much more about this, check out The Investor's Blueprint, Asset Protection Made Simple, our best-selling book available to you down in the description. Now, what if you put together a plan to protect your rental properties because you find out your state has weak laws, but then all of a sudden, once you think you have it put together, you realize your state also charges a tax to get the asset out of your personal name. How do you avoid this? Check out this next video where I break down exactly how you can avoid tens of thousands of dollars in real estate transfer taxes and how you can also make sure you protect that property while avoiding taxes at the same time. See you over there.